Okay. So last class we discussed some of the provisions with regard to agency relationship from third unit, and there are certain rights and obligations for both the parties, as we know, right? So in today we are going to discuss about duties of an agent. So duties, with regard to duties, we have 8 different types of duties. These are like serially sections are there: 11, 12, 13, 14, 15, 16 and 18. After that, we have 2 more duties from another different concept. So if you can try to remember these sections as well with regard to the duties and duties. Anyways, if you remember these headings, you would be able to explain that yourself as well. So you can try to remember the sections as well with regard to the rights and obligations, right? So regarding an agency, there are few duties that are given to an agent. Mostly when they are asking questions, they would either ask you define agency, what are the rights and obligations of an agent, or define agent, what are the rights and obligations of an agent. If it's a direct question with regard to what are the duties of an agent, then you can mention what agency is, that there are two different parties, principal as well as agent. Both of them would be having certain rights and obligations, because whenever there is a right that is given to a person, there has to have some duty given to another person, right? Without duties being assigned, without duties there cannot be any right? No one would be able to enjoy rights if someone else is not having some duties or obligations. So that thing you can mention with regard to it. Now regarding duties of an agent, what are the duties that we have? We will see. So duties of an agent, there are these 8 different duties. First one is duty to follow the directions of the principal. Usually in most of the cases, what may happen is there would be like a written agreement. In case of LIC and all, mostly there will be a written agreement where everything will be mentioned, right? That being an agent, you need to approach customers, you need to try to convince them to buy our policies. This is something that you got to do, this is something that you should not do. There will be already a set of directions or guidelines mentioned in the agreement itself, and the agent accordingly will have to follow those guidelines or directions. So it's a duty that agent is following all the directions given by the principal in case directions are there, right? So it is section 11 of the Indian Contract Act that mentions with regard to this duty of an agent, duty to follow directions. When an agent is appointed, he is bound to follow all the directions given by principal with regard to conduct of the business. But there may be a case, because we saw, right, there might be an express or implied authority by which agent may be appointed. So there may be some cases where principal has not expressly mentioned that these are the directions or these are the guidelines you need to follow, but rather it would depend on the kind of business, right? What is the usual custom that people follow, right? Based on that we would decide. So in case there is absence of any sort of directions coming in from the principal, the agent will be bound to conduct the business of principal according to custom which prevails in doing business of the same kind at the place where the agent is conducting such a business. How is it that people usually perform such kind of a business, or how is it that people usually do that kind of a business? Same thing you also need to do. Same directions, same principles would be applicable to the agent, even though there is absence of guidelines from the part of principal. So if we have proper express guidelines, we need to follow it. Otherwise, whatever is the usual custom, however people usually do it in that specific area with regard to that kind of a business, we need to follow that. And when an agent acts otherwise, if any loss is sustained, he must make it good to the principal. And if any profit he is able to earn, that also he need to disclose to the principal and accordingly hand it over to the principal as well. So this is with regard to the first duty. If principal is giving you directions, you need to follow that. If not, whatever is the usual custom, however people usually carry forward that kind of a business, that thing only we need to do. So this is the first duty which we have. So basically, agent is bound to do two things. If there is some direction given, he need to conduct the business based on those specific directions or guidelines only. If not, in absence of such directions, he will have to perform it according to the custom that prevails with regard to it. So these are the two things that comes under the first duty that we have with regard to following directions given by the principal. If directions are there, we need to follow it. If not, then we need to follow whatever is the usual custom. If we are not doing it and we have sustained some loss, we need to make good that loss. In case we are earning any profit by that, that also we need to give to the principal. So both the cases, principal should not be suffering any loss because of agent's fault or something like that. This is clear, right?
Yes, madam.
So there is this illustration, just an example. You can put illustrations as well when we are discussing rights and obligations. You can mention them as well. So this is first illustration where an agent engaged in carrying on for B a business in which it is custom to invest from time to time at interest the money which may be in hand omits to make such investment. A must make good to B the interest usually obtained by such investment. So principal might not be giving us directions every single moment, but it might be a custom only that whenever this amount is received by us, we need to invest that amount. And based on that investment, the principal or the agency business as such would be earning some amount of interest out of the investment. So in case the agent fails to make such an investment, which is usually like a custom only, in such a case, agent will have to compensate that loss, right? Which the principal will be suffering in sustaining in case of its absence. Like there are some these locally run these saving scheme things are there, right? Like few people from a certain community would be initiating that, where you need to just invest, might be like 500 rupees, 1000, whatever you want, and you would be earning some profit. And if those people want to take a loan also, they can take loan from that thing. Are you aware of that? There is that kind of thing very much prevalent.
No, I couldn't get what did you mention, madam?
Like like it's not like a very well organized financial institution, but like few people, right, from a certain community would come together and they would decide that we are going to, like collect money from people. Basically, those people can invest, right? Like 500, 1000, whatever amount it is, small amounts they can invest. And this community, they will again invest it somewhere, and like they would be earning some profits and some portion they would give. Those kind of things are very popular actually. Some small
kind of a microfinancing or a cooperative society.
Yeah, like in a less organized form, we can say like that only. So take for example, that kind of a thing is there, okay, like an agency where what happens is, when they are receiving that 500, 1000, whatever the amount is, the moment they are receiving it, they should be investing it somewhere so that they can earn some interest, some profit, and they can distribute some portion of it to the people who are actually saving there. In such a case, like investing becomes very important, right? Otherwise, how are they going to pay the amount to all those people who are saving there? In such a case, if agent fails to invest the money once he has received it, he is just keeping it with himself only. That means money will not grow, agency will suffer loss. So in such a case, the agency or the principal might make the agent responsible that you need to make this much amount of money, like whatever we have sustained loss, right? Because we were not able to earn an interest for a certain duration. So whatever might be the amount of loss, you need to accordingly pay that much amount. So here what we are doing, might be there was no clear direction that, okay, fine, you have received this much amount, now you invest it. But that is like a custom, that is the very basic thing, right, for their existence. If that itself is not done, then in such a case it can be done. Like it was something which is expected out of the agent. If you are not doing it, you need to undo the loss or harm that the agency has suffered, right? So this is an example. It's clear, right?
Yes, ma'am.
Okay. So these examples you can give whenever you are writing about rights as well as obligations. Now there is another one. So B, a broker in whose business it is not the custom, right? It's not the custom to sell on credit. You need to take the money and then only sell something. On credit, you should not be selling. That is the custom there. But a broker, he sells goods to A on credit, goods of A on credit to C. He sold some goods to another person being a broker and he sold it on credit, whose credit at that time was very high. Whose credit at that time was very high. C, before payment, becomes insolvent. B must make good the loss to A. So being this broker, he sold something to another person on credit, but it was not the custom. You should not be selling something on credit, but the person did it. The amount was very high, and later on this buyer becomes insolvent. He is no more able to repay. In such a case, agent may be made liable that it was not the custom. You should not have sold something on credit, but you did it. As a result, principal sustained loss. So now it's your responsibility to undo the harm or undo the loss that the principal has sustained, right? So these are examples when might be there is no clear-cut directions from the principal, but what is the usual custom? Based on that, we are saying that this should not be done by the agent. If he is doing, he will be made responsible. So that is like the first duty which we have. And there is this case also where an agent purchased some goods for his principal and stored the goods in a godown. Agent was also under the instructions to insure the goods. So apart from buying the goods, storing the goods, agent was also under an obligation to insure the goods. But he failed to get the insurance done. He just bought the goods and stored them in the godown. So the goods were destroyed by fire and it was held that agent was responsible to compensate. Why? Because there was clear-cut direction from the principal that agent also should be insuring the goods, right? So if he fails to do that, he fails to follow whatever directions or instructions have come from the principal, and as a result, agent can be held liable as well.
Okay.
There is another one where principal directed his agent to store. These two are kind of similar only. Here they failed to buy the insurance, and here what happened is principal directed his agent to store his goods at a particular warehouse. But agent stored a part of the goods at a different warehouse, which was equally safe. Both were same sort of warehouses, but he stored it in another warehouse where he was not actually instructed to store it. And those goods were destroyed by fire. Whatever was stored in a different warehouse, even though that was equally safe, that got destroyed by fire. And agent was held responsible to, like compensate for the loss. Why? Because there was clear-cut direction with regard to it that where the goods need to be stored, but he failed to follow again the directions or instructions given, right? So for both the two things, you have like examples or cases. You can accordingly put one example that with regard to directions, if clear-cut it's mentioned, we need to follow it. If not, whatever is the custom, we need to accordingly do it. So this is the first duty which we have, duty to follow the directions of the principal. Next one is duty to carry out his work with reasonable care and skill. Now, when an agent is hired, why is the principal hiring an agent first of all? Might be because principal is not having time to get everything done himself, or because he wants some skilled person to take care of some specific fields. So when an agent is hired, that person would be having some sort of skills or knowledge with regard to that specific thing, right? So when an agent is hired or when an agent is assigned with some specific tasks or responsibilities, it is done because of that knowledge or that skill that the person is having. But it is done mostly because agent is skilled in performing such kind of a work. So an agent is bound to act with reasonable diligence and also to use such skills as he possesses. So whatever skills you have, whatever knowledge you have, you need to make use of those knowledge. Whatever like safety steps you can take, you should be taking those steps. Why? Because agent is hired for that specific purpose only, right? It's not that simply because someone is given a task of writing something, the person would just write it. The person should try to write it in a very convincing way that whoever reads that particular thing, they would be interested to, might be join that partner agency or whatever it is, right? Might be opt for their service or whatever it is. So whatever skills the agent is having, he should be making use of that. He should be extra careful with regard to whatever he is doing, right? Like proper care and everything he should be taking. In case the principal sustains any loss or damage because of direct consequences of agent's neglect, he must be compensated by the agent. So in case principal is sustaining any sort of damage or loss which is direct result of agent's negligence, in such a case, agent should be compensating the principal with regard to it. Now, what is direct consequence of agent's neglect? Have you got it somewhere?
Direct consequence of agents neglect. Consequence of agents. No, ma'am.
So there actually is a concept, okay, that you get in the general principles with regard to law of contract, like the first part which you have. There is a concept called as remoteness of damage, okay? So it basically tells you like when there is kind of a contract, parties fail to perform their obligation, who is going to compensate and how much are the parties going to compensate, right? So this is related to how much will parties compensate. So you need to compensate as much as of loss sustained by the person because of direct result of your negligence, right? So remoteness as in like remote that we use for TV, right? Why do we use remote? So that we can operate it from a distance, right? We don't need to go and touch the TV actually to operate it, but from a distance we can operate. So here also same thing, it implies remoteness of damage. That means whatever loss I have sustained, how remotely is it related to your negligence? Okay, so if there is like this much of distance between your negligence and my damage, that means there might be many other contributing factors that have also contributed in me sustaining the loss. So I cannot make you responsible for all of those other factors also. But if both these two things are directly related, like proximate cause, we say, in such a case only I can make you liable. Okay, so there are basically two different words called damage and damages. So any idea what is the difference between these two words, damage and damages?
Is it a plural only? No. So more than one damage will be a damages in general.
Damage means loss or injury, whatever we have sustained, whether it's in terms of money, comfort, health, whatever it is. But damages do not mean plural of damage. Okay, even if it's multiple loss, multiple damage, we would say damage only. So damages basically means compensation.
Okay.
Damages means compensation. So when someone sustains loss or harm, that person will be compensated, and that is called as damages. Okay, so what happens is, whatever loss or damage principal has sustained because of direct consequence of agent's neglect, that means it should be very clear and evident that yes, it was because of agent's neglect only principal has sustained the loss. There should not be any other probable causes that you are saying that yes, agent's neglect was one of the factor, but then this also happened, that also happened, this also happened, and collectively principal has sustained loss. It should not happen. Whatever is the direct consequence, only because of agent's neglect, whatever principal has sustained loss, for that he should be compensated. Okay, so if the loss sustained by principal can remotely be associated with agent's neglect, the same need not be compensated. Like somehow you just, like somehow you make the agent responsible. That should not happen, but it should be very clear and very evident. Only in such a case we can make the agent liable. So principle of remoteness of damage will apply in this case as well. Remoteness of damage, as in we would see how remotely is the negligence responsible for the loss that the person has sustained. Like, is it clear, remoteness of damage? I can give you one example if not clear.
One more example, madam, please.
There is one like case that we get in law of torts, right? There we have this concept of remoteness of damage. There we get one example. Okay, there were like two friends. Okay, A and B were like two girls, and they were like friends. They booked a bus ticket. So from somewhere they were going back to their home. They booked a bus ticket from a certain agency. They booked a bus ticket, and accordingly they started their journey. Like at night they started their journey. But now what happened was, there was some sort of problem and some kind of like misunderstanding, and this bus they, like the driver and conductor, they dropped them in at a certain different bus stop. Okay, because they were going to some other direction and these two girls had to go to some other direction. So it was because of this agency's mistake, or the bus uh, corporation's mistake. They gave them some different ticket, and as a result, late at night, these two girls were dropped at a certain different bus stop because bus was going to some other direction. As a result, these two girls had to walk like some 5 kilometers at night because there was no other transport available. So they had to walk around 5 kilometers to reach their home late at night. After that, one of them fell sick. Right? One of them fell sick and another one was fine. Now they filed a case before court asking for damages or compensation. Now what did they say? They said that because of this, like misunderstanding or issues with regard to this corporation, we were dropped at a different bus stop. We had to walk 5 kilometers at night. That means we had to undergo some, like discomfort, right? Basically, we had to walk 5 kilometers late at night. So for the discomfort or inconvenience that was caused, they filed a case that we should be paid compensation for whatever inconvenience we had to suffer because of their loss. Also, one of these girls who fell sick, she also said that I also fell sick. So for that also bus authorities need to compensate me, right? So they need to be compensated for the inconvenience, and one of the girls fell sick, so she should be paid additional compensation with regard to it. Now, what did court say basically is that court applied this principle of remoteness of damage. Right? Court said what is directly related, that you suffered inconvenience, you had to walk 5 kilometers late at night, that is something which is direct result of negligence, misunderstanding or fault of this corporation. So yes, they will be paying you compensation with regard to it. But now, why did one of the girls only fell sick? Is it because her immunity was not that strong? Is it because she was already not feeling well? Or is there some other factors, right? There might be multiple factors which also contributed, right? So you cannot simply make the corporation liable for every single thing. Court would see remoteness of damage. How remotely is it related? How remotely is your suffering related to this particular issue, right? If they see that there might be other contributing factors as well, in that case, the like corporation was not held liable. So corporation was made liable for the inconvenience that they suffered of walking 5 kilometers late at night, but not for the sickness that one of the girls only had, right? Because there can be other multiple factors also which contributed. We cannot clearly say it was because of their neglect only. So this is what remoteness of damage is. Is it clear?
Yeah, now it's clear.
Basically, we have a duty to use all our skills with proper diligence. We need to perform our task. And if something goes wrong also, court would see, apply this principle of remoteness of damage. They would see how closely is it related, how remotely is it related. Accordingly, it would be done. And also there is one thing which is said, direct approximate result of, right? So what it is said is loss must be a direct. Whatever loss the principal has sustained, right? That loss must be a direct and proximate result of negligence. That means there should not be other factors contributing in it. It should be direct and proximate cause of the negligence. So this is what the second principle is. First of all, we need to follow directions or instructions if there is any. If not, we need to follow the custom which people usually do. Secondly, we have a duty to make use of all our skills, diligence, whatever thing we have, we need to make use of that. Otherwise, if something goes wrong and there is direct and proximate relation between the loss and our negligence, the agent would be made liable. So there is this example also. An agent for the sale of goods. He was an agent who was appointed and his main task was sale of goods. And he was also given the authority to sell on credit as well. That means on credit also you can sell, and this is the authority that you are being given. He sells to B on credit without making the proper and usual inquiries as to solvency of B. If you are selling something on credit, you need to ensure that the person is able to pay also, right? Like we see, right, this EMI, no cost EMI and all that stuff would be given. But that time they simply do not say that, okay, fine, you take it. They ensure that we are in a position to pay. They ensure that they are taking proper details from us that they can recover the payment, right? So same applied here also. An agent was there for sale of goods. He was having authority to sell, also sale on credit. He sold some goods to another person, but without making the necessary inquiries with regard to solvency of this person. So B, at the time of such sale was insolvent. He was already insolvent, but the agent did not know about it because he did not make proper inquiry with regard to it. A must pay compensation to the principal in respect of any loss thereby sustained. So if the principal suffers some loss with regard to it, agent should be responsible. Agent will be made responsible with regard to it. This also would depend on what kind of agreement is there between the parties, right? It's not like straight away the person would be made liable, but there would be again certain additional clauses and all that stuff also that will be there. Like in case of banks and all, we say, right, sometimes they would give a loan. Before giving the loan, they would ensure so many things, right? They would take care of so many things, but even then sometimes they are not able to recover. This may happen, that may happen. So it depends on the agreement that is there between the two persons with regard to it, that how things would be dealt with. So this is the second duty that they have. Might be if there is like one person who is appointed as like a cashier on a certain store, that person should ensure that whenever he is getting money, he properly counts it and only the balance amount he gives, right? If he makes a mistake that instead of giving 500 rupees, he gave 5,000 rupees, then the person may be held liable. Why? Because he was negligent, he was careless in performing his duties. And obviously, if someone is appointed as a cashier, some amount of diligence, some amount of skill the person would also have, right? So it would accordingly be ensured. So this is the second duty that we have under section 212 of Indian Contract Act. Now, third one is to render proper accounts to his principal. It is section 213. An agent is bound to render proper accounts to his principal on demand. Now, whatever dealings the agent is doing, he should be maintaining a proper account with regard to it, and that should be made available if principal wants to have a look at it, right? So on demand, principal must be supplied with regard to accounts, right? Whatever he is dealing with, he should be having proper records of it. Now, with regard to this, there was a case, like it basically says that on demand, like principal can demand that show me the accounts. And in such a case, agent is having an obligation. But in this case, like opposite only happened. What happened is agent filed a case against principal for rendition of accounts of the accounts, of accounts, and the Madras High Court observed that whatever duties assigned under section 213 of Indian Contract Act, it is provided that agent is bound to provide accounts in case principal is asking for it, right? When principal demands, agent should be supplying it. But there is no provision under Indian Contract Act which empowers the agent to file a case for accounts against principal. That means agent should not be going to court and saying that why is the principal not asking to, like see the accounts. Principal must be made responsible. Principal must be asked to check the accounts. That should not happen. In case principal is interested, principal will himself come forward and accordingly agent will have to show the records. But it should not go the opposite way, right? Agent should not be filing a case, but rather he should keep everything ready. Whenever principal demands, he should be in a position to provide all those details or records with regard to accounts that he is handling. So is this part clear? Accounts.
Yes, madam. Yeah.
To communicate with principal, section 214. So an agent is bound to render proper accounts to the principal on demand. It is duty of an agent in case of difficulty to use all reasonable diligence in communicating with his principal and in seeking to obtain his instructions. In general, we need to use our skills, we need to use diligence and perform our functions. We need to keep accounts ready and available if principal is demanding at any point of time. But there might be certain situations where there is a difficulty. Agent might feel like, what should I do in this kind of a situation? In such cases, agent should try to make all the efforts to communicate the same to the principal, right? He should communicate with principal that this is the difficulty that I am facing. what should I do? And he should accordingly, whatever instructions is obtained, he should perform accordingly. So there was this example that you can mention here. So when there is a difficulty, we should ideally be asking for instructions from the principal. If it is not received, not possible, not available, then we can use our own decisions and deal with that emergency situation. So what happened in this case is one person sent 100 boxes of grapes to an agent who was there at Allahabad. So he sent 100 boxes of fresh grapes. And he was given a duty that once you receive these boxes, immediately you need to courier them to Mumbai. One person is there at Mumbai. You need to send it to that person. But now when the agent received the grapes, he came to know that it's not possible that these grapes would remain fresh when it reaches Mumbai. So it's not possible. These will get damaged. In such a situation, what the person would do, right? In such a case, he will have a duty to communicate it to the principal. He may say that these grapes will get damaged if I'm sending it to Mumbai. So rather, can I sell it somewhere in Allahabad only? And whatever money I am getting, can I just buy another 100 boxes of grapes with that and then send that? Whatever is the suggestion, right? Accordingly, the person would be doing it. So this is to communicate to the principal. Whenever possible, the agent should make all the necessary efforts to communicate with regard to any difficulty or emergency that has taken place and wait for the instructions, right? Whatever instructions is received, accordingly he will perform. If instructions are not available, communication is not possible, then he would deal with it like an emergency situation. This is the fourth duty that we have. First of all, whatever instruction is received or whatever is the custom, we would do accordingly. Secondly, duty to carry out his work with reasonable. Whatever skill we have, we need to make complete use of it. Render proper accounts. We should keep the accounts ready. Whenever principal is asking for or is demanding, we should be able to provide it. We need to communicate with regard to any difficulty that might be there and wait for instructions of the principal. These are the 4 points that we discussed. Now, duty not to deal on his own account. When there is an agency, obviously agent should be working for benefit of the agency and not for his own personal benefit. For his own personal gain, he should not be working, but rather he should be working for benefit of the agency only. So an agent is bound to render proper account to his principal on demand if an agent deals on his own account in the business of agency without first obtaining consent of his principal and acquainting him with all the material circumstances which have come to his own knowledge on the subject. Principal may repudiate the transaction if the case shows either that any material fact was dishonestly concealed from him by the agent, or that the dealings of the agent has been disadvantageous for him. So principal is having this thing that principal should ensure that whatever agent is doing, it's for my benefit, for benefit of the agency. If not, principal can say that this transaction is not valid or I'm not, following this transaction. So agent should always work for benefit of the agency, not for his own personal benefit, that he is trying to conceal some important facts and trying to gain some benefits at the cost of the agency suffering some loss, right? That should not happen. Like there is this example which would make it clear, I assume. Like one person, right? One person directs the agent. Like principal basically says to the agent that I have this property and you need to accordingly look for a buyer, right? For this property, you need to look for a buyer. Now, principal is not aware that there is some like hidden mine inside it. He is not aware about it. And just before the sale, agent comes to know about it. That agent comes to know that there is some, like mine that is there inside the estate, and he comes to know about it, and he do not disclose it to the principal, but rather he goes to another person. He goes to a possible buyer, tells him that there is some hidden mine. You are going to earn enough of profit if you buy this property, but you need to make certain payment to me, and you can accordingly buy the property. I will convince the principal and everything. You don't need to pay anything extra to the principal, but you need to make a certain payment to me. In this case, what agent is trying to do, he is trying to work for his own benefit, not for benefit of the agency, but rather he is trying to cause loss to the principal. That he is trying to hide some important facts, and he is accordingly trying to get a deal signed. So in such a case, if principal comes to know about it, principal can say that, no, I'm not going forward with whatever transaction you have planned, and accordingly principal can withdraw from it. So basically agent would be having a duty not to deal on his own accounts, not to cause loss to the agency relationship for his own personal gains by hiding or concealing some important facts and all the other stuff. So that's also a duty that the agent will be having, that he is not working on his own account, but he is working for benefit of the agency only. Next one is duty to pay sum received for principal. So this is very simple. Subject to any deductions applicable, an agent is bound to pay to his principal all sums received on his account. If agent has received some money, because agents would be given many powers, right? Like take for example, there is like a guest house and a manager is being appointed there. Manager would be taking care of everything, like cash counter, dealings, everything he would be taking care. Whatever money the like the manager is getting, that money he needs to give it to the principal, right? The entire amount he needs to give to the principal, subject to deductions applicable. Might be he is also having a duty that you need to ensure whatever maintenance is required, you can invest some money with regard to maintenance of the guest house. So he can accordingly make use of that money. Whatever is remaining, that thing he needs to provide to the principal. So it is duty to pay sum received for principal. On behalf of principal, he has received the amount. So he should be accordingly making the payment to the principal, entire amount, subject to whatever deductions might be applicable. Whatever authority he is basically been given, accordingly he will do it. This is section 218. Now these two, right? These two are from different parts. So sections are quite different here. Like to protect the interest of principal, section 209. When an agency is terminated by principal dying or becoming of unsound mind, if principal has become a person of unsound mind or person he died, as a result agency is being terminated, the agent is bound to take on behalf of the representatives of the late principal all reasonable steps for protection and preservation of interest entrusted to him. So he should not be like, okay, fine, principal has died, legal representatives are not much aware with regard to this agency, so I should be taking all the profit, all the benefit. That should not happen. He has a duty to protect interest of the principal. Even though the principal has died, whoever is the legal heir, that person, he should, like not try to deceive basically, right? Whatever he would have done for the principal, same responsibility or obligation he would be having with regard to the legal representatives also. He should try to protect their interest also and not to deceive them. So this is from termination part, section 209. And last one we have, that is not to delegate authority. What is delegating authority?
Giving power.
Giving power to someone. So under agency, already principal is delegating his authority to agent, right? So agent should not be further delegating his authority. That also is a duty, not to delegate authority. Agent was already delegated the authority, so he should not again sub-delegate the authority to someone else. This is a provision from sub-agents, okay? So it is section 190 of Indian Contract Act. An agent cannot lawfully employ another to perform acts which he has expressly or impliedly undertaken to perform personally. When an agent is appointed, usually it is expected that the agent would be performing the work himself. So when there is such kind of an understanding, agent should not be delegating it to some other third party, unless by the ordinary custom of trade, a sub-agent may, or from the nature of agency, a sub-agent must be employed. For certain areas, it might be such that it's like very common that the person is not himself going to do it, but rather he would be appointing a sub-agent. So if it's very common, or if it's very usual or very obvious, in such a case, the person can appoint a sub-agent or delegate his power, but otherwise not. So if like we are going somewhere buying something, right, there would be like home delivery. We obviously know that owner of that shop or the manager is not going to come and deliver it to us, but rather they would be having some agents appointed for that purpose. So if it's something very common and very obvious like this, then in such a case, authority may be delegated, but otherwise not. Because otherwise we usually assume whomever we are delegating the authority, that person is only going to perform. So when there is such kind of an understanding, the person should not ideally be delegating his power to a sub-agent. That is like the general rule. This concept is based on a legal maxim that we have, that is delegatus non potest delegere. That means when you are only getting some power from delegation, you should not again like sub-delegate. An agent cannot in ordinary circumstances delegate the duty that was delegated to him. Already I have got something because it was delegated to me, I should not be again further delegating it to someone else. That is the ordinarily what prevails, and it would be applied. This principle is based on the idea that when a principal appoints an agent, he does so by placing his confidence and trust in the agent. Because principal is having some amount of trust and confidence in skill and efficiency of the agent, so only he was delegated that authority. And that same level of trust and confidence principal might not be having on some third party. So that is the main reason why we say that once something I have got as a delegated authority, I should not again be further delegating it. So it's like a very common example that you can give, that there is a person, A is employed as an agent. A is like a freelance content writer. He is appointed as a content writer, freelance content writer for a website that the principal owns. And he is given the task that you need to write some posts for the website and accordingly give it to the principal. Why is A given this task? On the basis of his writing skill and command over the topic only. So in such a case, A should not be delegating his power to some sub-agent, because everyone has got their own writing skills. Obviously, because principal liked the writing skill of this agent, authority was delegated to him. So he again should not further be delegating it unless and until he has taken proper approval from the principal, right? So this is another duty that we have, not to delegate authority, like not to sub-delegate basically, because the agent himself has received it under delegation only. So is it clear?
Yes, ma'am.
Any point you want example or to be repeated or something?
No, it's clear.
So these were the duties which we have, 8 different types of duties with regard to agent. So you can, like, if you remember this part, it should be clear, right? This much only, if you remember, it should be very much clear. You would be able to explain with regard to all of these also, with might be some
Yes.
examples you can take. Yeah. All right. So fine, then we'll continue with the rights of agent and principal, as well as duties of principal in the next class. So just one part was remaining for agency, and we'll complete that one. Okay. I saw a few questions also from previous year question papers. These things were asked. Basically, one additional thing was there, which also I have added here. Okay.
Okay.
Yeah. So regarding termination of agency, we are left with another question was with regard to sub agent, and yeah, I think that's all. Okay, and one more, I guess. So we'll see that part. So last class we saw regarding this, right? Creation of agency. Then there were this few ways of creating it. So you can explain on any of those points, right? That this is how it might be created, ratification and all that stuff. So with regard to termination also, it's more or less similar, only that we have few points or few ways by which it may be terminated. Okay, so termination of agency, what is it? That we are putting an end to this contract that is there between these two parties, where one person was acting as an agent or a representative of the other person. So termination of agency, we have provisions under sections 201 to 210 of Indian Contract Act as well. So you can mention these sections also, and you can give a basic intro on what termination is and why is it important. That if agency is created, it's not like for their entire lifetime they are going to continue. Sometimes their need or purpose may end at an initial stage also, right? So they should be having this option of putting an end to this agency relationship. How it can be terminated? There are basically two ways by which it may be terminated. Under both these ways, we have few different provisions. Okay, like we have by act of parties, that either agent or principal is doing something, and by their act or conduct they are putting an end to the agency. That is nothing but act of parties. And another one is by operation of law. That means there may be some provisions in the agreement itself, or there might be some law which is being applied to them. As a result of it, there is an end that is there to the agency relationship. Okay, so by operation of law, it may mean there is some provision in the agreement, and because of that specific provision or clause, it is getting terminated. Like agreement also is like law only, right? When I agree to do something, it becomes like a law, it becomes binding on me. So if there is a clause based on that it is getting terminated, we would say that it is by operation of law. Why? Because that specific provision of the agreement is applicable on me just like any other laws would be. So these are the two ways we have, by act of parties or by operation of law. When we say act of parties, we know there are two parties in an agency relationship, obviously principal and agent. So what can be the act of parties? It may be by mutual agreement. That means both the principal as well as the agent wants to put an end to the contract, right? So it might be by mutual agreement. Both of them want to put an end to the contract. Accordingly, they will do it. That is coming under act of parties, that they are doing something As a result, this contract is getting terminated. All right. First is mutual agreement. Second one is when agent's authority is revoked by principal. Obviously, when discussing rights and duties, we have seen that principal would delegate some authority to the agent and agent is supposed to act accordingly, right? But principal is having this option of revoking authority. If principal revokes or takes back the authority given to the principal, that would also lead to termination of the contract. That means here it is done by principal because of some act of principal, that is revocation of authority, there is termination of contract. Similarly, when agent renounces the business of agency, that means agent himself is saying that I want to put an end to this, I don't want to act as an agent anymore, I want to separate myself from it, that also may lead to termination of agency. So when we say act of parties, it may be because of an act of principal, because of an act of agent, or it might be a mutual agreement between the two persons. So we basically have three things, and this is like you can remember also, right? There are two parties. It might be because of principal, agent, or because of both of them. That is mutual agreement. This is revocation of authority by principal, and this is renunciation of business by the agent. So these three we have under by act of parties. Then next one we have is by operation of law. That means some law which is applicable to the parties is being applied here, or because of any provision in the agreement, the agency relationship is being terminated. Now, first one we know, right, that agency might be for a specific task also, right? Like auction and all, you need to sell this horse. For that, there is an agency relationship. Once this task is being completed, definitely agency is going to come to an end, right? So it might be terminated when business of agency is completed. If it was only for one specific business, like that of auction, selling something, once the purpose is being done, it would come to an end, right? Someone may appoint a broker as an agent to find a buyer for, like he wants to sell a house, he may appoint a broker, right? That you need to look for a buyer. Once he gets a buyer, the deal is finalized, sale is done, it again would come to an end, right? So this is when business is completed, this provision would be mentioned in the agreement itself that we are going to put an end to this relation once this purpose is completed, the business is done. So this and the second one are similar by expiry of fixed period of term. If the term was fixed that we are acting as an agent and principal only for 2 years or might be 3 years, once this term is being completed, again, agency also would come to an end unless and until they have renewed it. Like in the agreement, they may have a provision that initial validity of this agreement is going to be 2 years, but there is a provision to renew it or extending its validity, right? There might be a provision or there may not be. It's not like necessary. So if they have not renewed it, there was no such provision. Once this fixed period is over, then also agreement would come to an end, agency will be terminated. So these two are kind of similar. Here business is done, here term is over. There was one case with regard to this one of expiry of fixed period. So what happened here basically is that there was an agreement between two persons with regard to running a petrol pump for a specified period. So when they entered into this agency relationship, time frame was specified during which this petrol pump business will be run by them. It was held that agent was bound to vacate the premises on expiry of period. There was no renewal clause, nor in fact there was any renewal. So if you do not have any renewal clause and you have not renewed the agreement, then it indicates that your contract will come to an end once this period is over. If you have got a renewal provision, might be they would say that once agreement is coming to an end, just, like before 1 month, they would give a notice to get the formalities done. Might be we would extend 1 more month, like that. There might be provisions. If there is no provision as such, once the time frame is over, and if it is not being renewed, we would assume that this agency has come to an end. Okay, so these two are based on whatever is mentioned in the agreement, right? Based on that, it is being terminated. This is clear, right?
Yes, madam. And probably a common sense which can be applied and based on which we
Yeah,
can
common
write.
sense things only. Like from the name also, it's very clear that, okay, fine, operation of law. So there is some issue with regard to this numbering thing. See, I don't know why.
Sorry, what happened?
Like this numbering, right? Some issue is there.
Okay.
C again, C is coming. D, E.
Actually, it is taking the different series. That is the reason.
Yeah, that's right. I added this case from somewhere now, so that's the issue, I guess. Okay. So that those two things are there. Whatever is mentioned in the agreement, based on that, we have these provisions. Then, when either of the parties dies or becomes mentally disabled, like in while discussing about the this right eligibility of parties, who all are competent to contract, or who all are competent to appoint an agent or be a principal. We have seen that parties should be mentally sound, and obviously parties should be alive to perform their rights and duties. So that again is like a common sense thing. If parties only die, if agent is not alive, if principal is not alive, then there is no question with regard to it, right? That the agency would continue. Same would happen with regard to they becoming insane at a later stage. So if any of these two things happen, then also it would lead to termination of the agency or termination of the contract. Then when principal is adjudicated as an insolvent, if he is declared as an insolvent, then also he is not entitled to have an agent, because he will have to pay the agent, right, for whatever services he is providing. So if he himself is being declared as an insolvent, then also this agency would come to an end. It will be terminated. Then we have destruction of subject matter. So basically there would be some purpose why they have entered into the contract. If contract was because one person wanted to sell a horse, right? Might be he appointed an auctioneer as an agent, and I want to sell this horse and you need to help me out with that. If horse only dies, that means destruction of subject matter. For whatever purpose you had entered into the agency, that matter itself is no more existing. Horse only died, that also would lead to termination of the agency relation, right? Because it would again have no meaning continuing with that relation. Dissolution of company. There might be some, like firms or companies which may be regarded as principal in the contract of an agency. That sometimes it might not be one, like one individual, but rather it may be one company or one firm. Like it may be LIC, right? So if LIC is the principal and LIC itself is dissolved, right? LIC itself is no more existing, then what will all those agents do? It's of no use, right? So if that entity only is dissolved, then that also would lead to termination of all these agency agreements that were there, right? Because agents would have no purpose after that, after dissolution of the company. So all these 1, 2, 3, 4, 5, 6, all these 6 ways are coming under by operation of law, and for act of parties we have basically 3. So 3 for this, 6 for this one, right? Here we have a combination of like general provisions as well as what is mentioned in the agreement, right? So based on that, it will be accordingly decided whether it is putting an end to the agency relation or not. Then there is one more thing which you can include in your answer. Like this one is a common question that they are asking basically. You can include this also, like time from which termination of agent's authority becomes effective. Okay, fine. We know that there is this provision of terminating the contract, but then from when it becomes effective, right? So with regard to that, we have these two provisions. You can mention that termination of agency does not become effective immediately. It would take effect against the agent when the fact of termination becomes known to him, and against third persons when they come to know about the same. Like when third parties come to know about it, might be they would publish something on a newspaper or their website or something like that. Like basically they are making it public that we are putting an end to this agency relation and all that stuff, and accordingly it will be terminated, right? It would depend on situation also, what kind of contract was there between the parties, whether they were contracting with too many third parties or not, like whether is it needed that they disclose it to public or not. That would also depend on the kind of contract that was there between them, right? If someone is hiring a broker that you find me you find tenants for my house, in that case if there is termination of the like agency relation, obviously landlord is not going to publish an ad somewhere and make it public, right? That there is no need in such a case. So these things also you can mention, right? I guess there was one question with regard to what are the ways by which an agency may be terminated, and a short note was there. So this is clear, right?
Yes, madam.
Yeah. So you can also mention what agency is, why is it created, why is it becoming so popular. After that, what is termination? Then we have these two different ways of terminating. Under that, we have 9 different ways by which it may be terminated, and accordingly, one conclusion you may give.